Thank you, everyone. It was great presentation, Lorelei and Doris. But I'm going to, little bit, Doris, say stuff which we can try to get free or provided by, different levels of government. So that's basically, it's very short, sweet presentation. And these are the benefits we have paid into in the past. So our aim here is to something which we have earned income and paid into it. Why not utilize it? And people should be aware of it. So first, I'm mentioning about death benefits. A lot of you, I'm sure, is aware of it, and I even mentioned in my last year presentation, the maximum death benefits based on the contributions is $2,500. So if you have been working in Canada, paying into Canada pension for a number of years, the maximum you could receive is $2,500, and executive or the next of kin, if there is no will, definitely what Doris said, we should have a will, but if one doesn't have, they should apply and receive those benefits. Last time I checked, they were taking 6 to 8 weeks to process those applications. So please do apply. That's something your work paid into it. Going back on the will, it is very important to have a will. But on the other hand, I also feel there is will which you get a package, you could get it from chapters, or you need to have a will. It's a good idea to get a will and get it done from the lawyer, but I have also accepted wills on a piece of paper. Somebody have come into Canada Pension, Old Age Pension Office and said, this is what my dad left and that's what I have. And once again, Canada Pension and Old Age accept those handwritten wills. And so we have taken it. Now, going back to enduring power of attorney, Canada Pension and Old Age have enduring power of attorney forms. They are ISP 3505. You go on the Service Canada website, you could look at it. But enduring power of attorney is only good while you're living. The moment you pass away, it's out, it's done, then you're dealing with will. So I really say if somebody who is brand new, been in Canada just 10, 15 years, and don't have much, and don't think that they have property or anything, then maybe it is a good idea for them to do just the federal government enduring power of attorney, which is you can use it for Canada Pension and Old Age Pension. Another thing is somebody who has not worked, paid into Canada Pension, there is $1,200 of benefits available from Alberta government. And you can go on Alberta website and you can find those. And that's only for low income and no income people. That is somebody who has not paid into death benefits, will not get anything from the federally, is not receiving old age pension, is not going to be entitled to any kind of benefits, then province will give you $1,200 and cover the funeral costs. Third is after the death, the surviving spouse is dealing with survivor's benefit, which is again, the calculation is based on the deceased Canada pension. How much they have worked, paid into it is the amount how much person surviving spouse or person who is living common law will receive. So again, please do apply. The best way to know if you would qualify or not is to apply. You're not going to apply, you're not going to get the benefits. Even if you get officially answered that you're not eligible, it is a good idea because you might need that to apply for some other provincial or some other level of government, some benefits. There is also child benefits, which used to be called a long time ago, orphans benefit. That's $250 per child. So if the person had passed away, there is a surviving spouse, there is also children, then they can apply for child benefits. You get it up to the age of 18. After the age of 18 to 25, as long as you are attending school or university full-time, you could get benefits for that. But again, you have to be full-time in school attending school or university. And they have their own hours you need in order to qualify, which they consider as full-time. There is Canada Pension Disability. That is again based on the contributions. If one has paid into it, then they would be entitled. Of course, the disability has to be severe and prolonged. One has to pay into the benefits. So as long as they have a contributory requirement as well as the disability condition, which is severe and prolonged, then you could qualify for Canada Pension Disability benefits. And then we have old age security benefits. Again, entitlement is based on legal residency in Canada. You need to be minimum, has to be in Canada for 10 years, as long as you need to be over the age of 65. And then you can get the benefits for that. Again, it's also income-based. They're going to look at your income, how much, they don't care how much money you have in the bank, but what interest you're earning on it is considered to be income. So, and then that's how the old age security and allowance for survivor. That is something they will again look at your income, what you have, how much interest are you earning, and that's how they'll establish how much is the eligibility for that. Guaranteed income supplement is again amount which changes if one passes away. So say you were getting and you had your spouse income, your income, and now that spouse is gone and you are surviving spouse, the amount will be again established based on your individual surviving spouse income. So these are some amounts. The maximum anybody can receive for Canada Pension for 2019 is $1,154. These amounts, of course, changes. I'm giving you the latest amount, what it is for 2019. There is a disability amount. Maximum you can receive is $1,362. There is survivor pension. If you're under the age of 65, the amount is different. If you're over the age of 65, the amount is different. So the under is, of course, there is average amounts are there and the maximum amount are there. I'm mentioning 692. Again, all these amounts, latest amount changes based on every year. Depend how many people are taking. So best thing would be to call the numbers, which I'll be providing end of my slide. So call the number, get the latest information instead of writing it down or anything. Then when you're calling the 1-800 number, you're getting latest and most accurate information. There is, of course, I mentioned about the death benefit, child benefits, and then there is combined benefits. You can get it for survivors and retirement, which is $1,154, and then the survivors and the pension, somebody who's have lost a spouse, so they're getting survivors, plus they're also getting their own disability benefits. It's $1,362. Okay. CRA, Revenue Canada. Once you lose a spouse, your marital status, or anybody you lose in your life, you are helping a friend or whatever, you need to remember few things always, that any change in your marital status, including the death, can change entitlement amount you receive from Canada child tax benefits, working income tax benefits, GST, Alberta carbon rebate, CRA. You can also inquire and benefit from obtaining CRA Clearance certificate. I know I did for my dad when my dad passed away. I thought it was very important for me after I have followed all how he wanted his estate been dealt and everything. I wanted to obtain that clearance certificate. This way I know that nobody owed any money, and Revenue Canada cannot come back later on and say, hey, you didn't do this or you owe this much or anything, because I was also dealing whole bunch of stuff overseas in India as well as here. So I thought getting a clearance certificate would be a good idea. Accountants can help you do that. You could go on the website, read it. I always try to do things more economical, easy way. and so if you can do your file taxes and you do it on your own every year after year, you've done your state income tax, best is to get even a clearance certificate. These are the useful telephone numbers. Of course, I'll mention always about Revenue Canada, 1-800-959-8281. You could get a bunch of information. You have called for GST, you have called for income tax, you could call for anything and everything. And if they don't have the answers, they'll guide you. All these, just by calling, talking, it really helps. If you won't, then you won't find out. You have lost a spouse, you are tight with money, you want to do things your way, or you don't want to waste money. I'll give you an example which comes to my mind is land titles office. You could go through a lawyer, they will help you and they'll do it, or you could go on the website, look at it, and find out land titles office where it is. I've taken few aunties myself and gone, and because one person passed away, the other person is living, I've gone. They'll fill out a $35 form on their own, and next thing you know, in the mail, 2 weeks, 3 weeks later, you'll get the house papers just on your name because now the other person had passed away. So, it is a good idea. I really say what Lorelei and Doris said. It's a great idea, do that, because, we always think this is not going to happen to me. This happened to that person or this, but you never know. It can happen to any of us. And, before we used to hear stroke would happen to somebody who's 50, 60. I'm hearing stroke happening to young children, stroke happening to somebody who's 25. So just, it's a good idea to have everything in order while leave mess for somebody else to do, clean up for us. And they do it in such a way we may not like it. So it's a good idea. I personally have even picked up my picture I want at the funeral. I don't want open casket. So it's a good idea to discuss, go into detail, talk to your spouse, talk to your children, and tell them what you want, how you want it. And if you don't want anybody to come to your funeral, you want private, then express that, tell them.
So basically, after death, what happens to loans and mortgages? And the answer is your estate has to pay them. So the amount, as long as you have money in your estate to pay the debt, your estate will pay them. If there isn't enough money to pay the debt, then your creditors lose. Nobody has to pay your debts for you. And so lots of times executors will say, do I have to come up with this money? And the answer is no. You don't. The executor doesn't have to pay. The next question is a handwritten will legal in Canada? Are there any issues with executing it? A handwritten will is perfectly legal in Canada. If it's all in your own handwriting and you sign it at the bottom, then that is a legal will in all of Canada. It's not legal everywhere in the world. If you have a formal will with 2 witnesses, you can pretty much count on that being legal anywhere. The personal directive, should it be given to family, doctor, or Alberta Health, or both? Is it available to the doctor if I fall sick outside of Canada? So it's available, so your personal directive, you can actually register. You can go on the Alberta Public Guardian's website, and they have a place for you to register your personal directive. And therefore, when you go to the hospital, they can look on Netcare and see that you have a personal directive. In terms of it being available anywhere outside of Canada, your agent would have to give it to the hospital. So it's important, as Lorelei said, for your agent to know where that document is. So don't hide it in your special spot and then nobody knows where it is. Make sure that your agent knows where your personal directive is so they can take it there. What is the average cost of preparing a will for a husband and wife? So in our office, the average cost for doing a will, a power of attorney, personal directive for a husband and wife is $950. If you're going to be more complicated, it might be more expensive, but that's generally the cost for doing those documents. Are wills laws different in each provinces, death benefits, etc.? The wills laws are provincial. So we have federal laws and provincial laws. So there are different laws in every province, but they're generally the same. So in BC, for example, we call documents differently. So there is a power of attorney, but there's also a representation agreement instead of a personal directive. And in BC, there's more litigation, so you can sue if you're an adult child and didn't get anything. In Alberta, you have to be a dependent child to get things. So they are different, but not so different that it's difficult. And for sure, in terms of whether your will is valid, it's the same everywhere in Canada. Next one. How to indicate in a will online or digital record password. If a person dies, is it not possible to get certain account information? So for sure, you should keep track of all your passwords and have somebody able to get them, because so much of our life is digital now. Digital banking, all of your social media accounts, and all of those are password protected. And it's so important that you have those somewhere, that your executor or your attorney under your power of attorney can get access to them, so they can wind up that part of your life as well. I'm not sure if the first part of this question had to do with a digital will, but you can't actually have a will online at this point. Like, you can't put it on your email and then send it to somebody. It has to either be in handwriting or it has to be written and then witnessed. So that part we still require. Still require in terms of writing. What is a simple fee for talking or seeing an attorney for your directive? So just for a enduring power of attorney and a personal directive, usually the cost is about $200 for each of those documents. But we usually do them as a package. But if you just wanted to do those two documents, you can. And those two documents we find very simple if you just want to do a really simple one. And so sometimes we do them, and then you can we give you instructions on how to sign them, so you don't actually have to come to our office to get those done. Sometimes people don't want to come to our office, and we're happy to help you get them done regardless of that. Is there a need to notarize documents? Good question. And how many witnesses do you require? So there's no need to notarize documents. Anybody who's not named in the document can be a witness. So witnesses just need to be 18 years old. So in your power of attorney and your agent, there's only a requirement for one witness. And in the will, there's a requirement for 2 witnesses. And they have to be together. So the person who's signing his will has to be in front of 2 other people who are not beneficiaries or the spouse of a beneficiary in the will. So it's a pretty simple process, but so important that you get it right, because if you don't sign the document correctly, then you really don't have a document. So the signing part is really important. And I think those are all my questions. Thank you.
I think this
one's
one
for
may
me?
be for
Okay.
you.
Okay.
Because I can't answer it. So.
Okay, thank you. When children inherit parental assets, what are the implications? Bank balance, RIF, real estate, equities, jewelry, and car. Please turn over. Where can I get, the green sleeve. So that's going to be your question. What are the implications? Well, I mean, ultimately, all of your assets are wound up on death. If I don't answer this question properly, please see me afterwards. First, you have to pay all the taxes, as we were told. So that's the first thing. You have to pay debts and taxes, and then the balance is distributed to whoever you have named in your will or whoever you've named as a beneficiary. And so if that's the question in terms of, first we're going to give out the assets where there's a named beneficiary. Those assets will not be used to pay debts, and then ultimately the other assets will flow under your will. We'll pay the debts with those, and then those go out to children or beneficiaries.
I just wanted to comment a little bit on the banking, and this was, again, a personal learning experience. When we moved a year ago, my husband decided, because I, for many years, have done all the banking, and we had to do all the address changes and contact information and update everything. So my husband said, I better start figuring out where all these bills start coming from, because now some are online, direct to MasterCard or whatever, some are mailed and emailed. So my husband, for the last few months, has been doing the online banking, but everything has passwords to it. So I do have a list of passwords, but it's taken him quite a few months. And even though he's so skilled with finance, I took this as a compliment when he came out of the office that one day doing banking, and he takes his glasses and he puts them down and he goes, honestly, you should have been an accountant for the mafia or something. There's so many passwords and different ways to log on. So that's another really good tip, is start learning now what your partner's doing or your parents, so it makes it easier than knowing what's there. So with the personal directive, I do know that you can get the personal directive for free through the Office of the Public Guardian. My experience in healthcare has been it's a really good idea to do it as a package with the power of attorney and the will, because I can't tell you how many times patients and families are in crisis when they may have had a personal directive done for free, but they realized they needed to update their will or their power of attorney. So it's really a good idea to do it all together. Where can you get the green sleeve? Any physician, family doctor's office should have a green sleeve. If they don't, they can get them for free. If you go to the Conversations Matter website that's on your resource sheet, you can actually get green sleeves mailed to you for free. And every time you're in the hospital, you should be coming home with a green sleeve. Most of the time, those goals of care designations are done. Oops. Green sleeve, will it be honored in other provinces and out of country? This is particular to Alberta, and same with the personal directive. What's important for us in healthcare is that you've had these conversations, so they may not be legally acknowledged, but what's important for us in healthcare is if you have those documents, we can see there's been conversations started and actually put on paper. So we're not starting from scratch wondering where has the conversation happened and what your wishes are. So those are good things to still have and take with you. And you don't physically have to take them either, right? With our iPhones, our smartphones now, I'm starting to learn to take more pictures of our documents. And that's an easy little file folder that you take with you. Clear-cut difference between personal directive and green sleeve. The green sleeve is that communication for your healthcare needs. So that's where the medical conversations will happen and that prescription for the focus of your goals of care are. Whereas the personal directive is that person that you've assigned to speak for you. And again, that person has to feel comfortable speaking for you and know that you've asked them to speak for you and should have a copy of your personal directive. How to download the app in the iPad. I haven't done it in the iPad, so I am sorry, but I would think if it's from the App Store and on the phone, you should be able to get it on your iPad as well. Can you explain step-by-step process what to do based on your experience? Contact person who can help. That's a big one. And really the easy answer that should be is anyone in the healthcare team should help you through these things, be able to help you through these things step by step. Start with your family physician when you're in the hospital, ask people. And I don't know the answers to everything either, so that's where I work as a team. So if someone in the hospital is asking me specific to personal directive or financial issues or concerns, that's where I work with my team in the hospital. We have our social workers that are able to connect with lawyers that can do in-hospital visits, for instance. And we have social workers also to help with those financial resources that might be available. Can a doctor or someone else override your personal directive? Does the personal directive have to be legally authorized? So this is a little bit of a tricky one about overriding your personal directive, because you would think you could write in your personal directive, I want to live on forever, do whatever you can, but is it clinically appropriate or even possible? So what if someone says, I want you to try to restart my heart if it stops? But what if you have a health situation where maybe you have that curvature in your spine where you're so bent over, we can't physically straighten you out to do chest compressions. So it's not physically possible for us. Or if you have such advanced cancer that your heart is naturally stopped, we will not be able to get your heart restarted again. So those are really important things, not to be too specific in your personal directive, but put your overarching goals. And does it have to be legally authorized? I think, Doris, you already mentioned that already, that you have to have 2 independent witnesses. You don't need a lawyer in that regard, and those witnesses can benefit from that situation. And I think that was all the, yes, that's all the questions.